can start. Welcome everyone, welcome to this talk. We're extremely delighted today to have Dr. Saiful Karim with us. Just a bit of an introduction. Dr. Karim is an Associate Professor and Director International of Law School at QUT. He teaches and researches in international law, environmental law, and he has extensive publications in those areas. He's also a lead author in the Intergovernmental Panel on Climate Change, special report on the ocean and cryosphere in a changing climate. The Australian federal government has also nominated him as an expert in intergovernmental science policy platform on biodiversity and ecosystem services. And also, Dr. Karim is a recipient of IUCN Academy of Environmental Law 2018 Emerging Scholarship Award. So in sum, he's truly an expert in international environmental law. So we are extremely honored today to have him with us to give us this talk. Okay? The way this is going to work is Dr. Karim is going to speak for about half an hour, and then we're going to have a Q&A session after that. Okay? I'll just hand it over to Dr. Karim.
Thank you, Dr. Todd. And I would like to...
You have 1 minute. It's okay.
Yeah. So, thank you. So I'd like to thank Faculty of Law, David and James for organizing this. I'm really delighted to be here. It's a very beautiful city, and this is my first visit to Hong Kong. I was in Singapore for some years, so unfortunately I was not able to come to Hong Kong in that time. So, as David said, actually my main area of expertise is international environmental law and environmental law of some countries, South Asian countries like Bangladesh and Pacific Island countries. I'm interested about Fiji. After moving to Australia, I started doing some research on Fiji. And I do research on marine environmental law is my main area. While doing research on marine environmental law, I actually somehow became interested about maritime security, particularly maritime terrorism, piracy and maritime terrorism. So I'm not interested about cyber security. That may surprise you. But unfortunately, it will probably a major maritime security issues. So if anything creates problem in the maritime security sphere, I am interested. So I'm not interested generally about cyber security or cyber laws, and I know very little, to be honest, about that. So my main area for this perspective is maritime security law, piracy, terrorism, and other non-traditional maritime security. So the threat, as you know, like any other places, any other business in the world, or any other areas, cyber security issue now becoming a major issue. In maritime area, it's already becoming a very complex and challenging issue for the industry. And that's why IMO issued a guidelines on maritime cyber risk management in safety management system. Okay. So, but the issue needs further negotiation in the IMO to establish an appropriate legal framework, because whatever IMO legal instrument I will discuss, the major problem is that when IMO, the member states through IMO adopted those legal instruments, they did not consider this issue. Okay. However, you can liberally interpret many provisions of existing IMO legal instrument, maybe conventional codes, to criminalize maritime terrorism. Okay. So I will discuss later also here. There is a broader issue of cyber security. Okay. But I'm mainly talking about maritime cyber terrorism, not the security as a whole. So the cyber security challenges may come from many different sources, and terrorism is one. And I have a very particular view about what is terrorism and what is not. I am one of those people who don't think piracy is terrorism. And terrorism is not, maritime terrorism is not covered by law of piracy. That's universal jurisdiction crime. The definition is, by definition, it is not. And actually many people, some people believe they want to interpret the piracy, maritime piracy, I'm not talking about software piracy, of course, maritime piracy, to include maritime terrorism, particularly after Achille Lauro incident, that was the Italian vessel hijacked by terrorists, and the passenger in that process was a US citizen. There was a huge debate about whether existing piracy law cover maritime terrorism. So, but the majority view, particularly those who are advising the major countries, the lawyers who are advising us that no, it doesn't cover it. That's why you have a new convention, suppression of unlawful acts, the SUA convention, which is the IMO convention. I will discuss about that later. So that covered the issue of maritime terrorism, although like many other, almost all other terrorism conventions, SUA convention does not mention the term terrorism. To cover actually, it was probably intentional to cover a wider, to make the scope of the convention wider, not to engage in that debate what is terrorism and what is not. So it has a very specific crime, which I will discuss later. Cyber terrorism, what is cyber terrorism? I've taken it from somewhere, as you can see I have provided the reference. Cyber terrorism is the convergence of terrorism and cyberspace. It is generally understood to mean unlawful attacks and threats of attack against computers, networks, and the information stored therein when done to intimidate or coerce a government or its people in furtherance of political or social objectives. That's the important part. So you can hack a shipping company's system to get information to conduct a perfect piracy. And that was done by Somali pirates. That's a piracy because they are there to get money, okay? But at the same time, you can do the same thing. For example, Al-Qaeda may do the same thing just to attack take a political revenge against a country they don't like, or a vessel. And that's the terrorism. So both the process, there is similarity, the intention is very important here. Okay. Cyber terrorism in maritime domain, we can call the maritime cyber terrorism. Cyber terrorism against ports, ships, and other maritime infrastructure. Maybe the maritime infrastructure we have for exploration or exploitation of hydrocarbons. Okay, or this type of thing. So this is broader than maritime cyber terrorism, both terrorism and other security issues. So when we talk about maritime cyber security, it's actually include everything. Whatever threats, security threats, shipping companies or other, or a vessel or a port may face because of cyber security issue. And that also includes cyber terrorism also, terrorism also. This is an example I have taken from, I've tried to take the example from official sources. You get lots of information online, and I have a tendency of following the things states submit in the IMO to have authentic information rather than using. So you can see there are some examples. Somali pirates employed hackers to infiltrate a shipping company's cyber system to identify vessels passing through the Gulf of Aden with valuable cargoes and minimal onboard security, which lead to the hijacking of at least one vessel, as I was giving example. And so the terrorist organization, existing terrorist organization, may take the help of the cyber criminals who are already engaged in their crime for some other aim to earn money, okay? There is a possibility that in the future those terrorist organizations, or they may have their own expert, as you know that even ISIS has its own technology department headed by someone who actually killed by the in that war. So they actually had, and you know they are using social media and all this thing to actually recruit people. So it is not unlikely that they may have their own expert, or they can use existing criminals, cyber criminals, to create problems. So there are some incidents. It was reported by, I think, one of the governments. All these examples, as I said, are taken from a submission to the IMO by one of the member states. So it's not coming from any non-government source. This is another official statement in the IMO by a state. As the global maritime community moves further into a digital environment, ports, vessels, and facilities are increasingly connected to and dependent on cyber systems. And more interestingly, at the moment there is a discussion going on in the IMO to have, at the moment there is a study within IMO going on about autonomous vessels, or in the future we may have vessels without any crew, entirely autonomous system which is running. Then if someone take the control of that vessel, that ship, what will happen? They can use it for purpose. So this type of thing, I'm not saying that this will happen, but okay, so because of the increasing dependency of I didn't expect a call, you can go on. Okay, so we may have more, the risk is there. The maritime sector is not immune to these potential vulnerabilities. So as you can see, cyber system, unauthorized access to the cyber system would result in compromised strategic proprietary or personal information and exploitation of cyber system for other purposes, as you can see. Okay, now come to the law, we should talk about. Whenever we talk anything in maritime space, we have to start with the United Nations Convention on Law of the Sea, which is, as Professor Tommy Coe, who was the chair of the last third UN Conference on Law of the Sea, which adopted this legal instrument, he said that it is the constitution of the ocean. So it's determined the jurisdiction and responsibility of the states, who has the jurisdiction over which area of maritime space, what is the responsibility of flag, port, coastal states, all these things. Then we have most relevant convention is SUA Convention, Suppression of Unlawful Acts Convention, and other terrorism-related international conventions. There are 19 international legal instruments. Not all are original instruments. Some are actually amendment of some previous instruments dealing with different issues. Safety of Life at Sea Convention, SOLAS. SOLAS actually mainly about safety, but after the terrorist attack in United States, 2001 terrorist attack, actually IMO actually did a comprehensive review of relevant laws. Then there is a new code, ISPS code, was adopted, there are IMO codes, there may be some IMO codes that will be legally binding, but this one is a legally binding ISPS code. To make it legally binding, they amended actually SOLAS Convention, and through that, then it's now actually in fact part of SOLAS system, SOLAS Convention system. So ISPS code is preventive, the way of prevention rather than actually prosecuting someone or creating responsibility, which is SUA Convention terrorism. Main aim of ISPS is to introduce a system which the vessels will follow to avoid this the problem of security issues. Okay. And then IMO recently adopted the IMO guidelines on Maritime Cyber Risk Management in Safety Management Systems. So these are legal instruments. The last one is of course not legally binding. This is just a guideline. So okay, I will not read all this either. I'm just showing you that already in the IMO process, it was identified that some of the sections, some of the provisions of ISPS codes are relevant for cyber security. That's why actually they did not amend ISPS code and issued a guidelines. Okay, if ISPS code is something totally not suitable for this purpose, they would have amended it and added a new chapter or something. That's why you have a guidelines rather than amendment to ISPS codes. So these are some of the sections, of provisions relevant for this. ISPS code and cyber security, as you can see. I'm not going to read this. At the same time, IMO guidelines on Maritime Cyber Risk Management. This is again how the shipping company should do it, how the master of the vessel will do it. We are not very much interested about all of these as a lawyer. Again, this is what they should do: identify, protect, detect, respond, recover if anything is stolen, any information. Now come to law, which is UNCLOS. Piracy, as I said in my 2017 book, and many other people said, provision of piracy are not suitable for maritime terrorism incident. However, it is actually, as I said in my book, it is actually relevant. When we are talking about, okay, piracy is not relevant, but UNCLOS is relevant. Because as a flag state, UNCLOS gave you all this right, and no right can be given without any responsibility. So if because of your faulty system, a terrorist gets registration, a flag from your country, even terrorist group can own a vessel and buy a flag to one of those flag of convenience country. What I argued in my book is that in that situation, if a country negligently provides a flag to a terrorist group, registration to a vessel, and if that vessel is used for terrorist acts against a country, that flag state has some responsibilities. Piracy is different. I'm not discussing about piracy, but responsibility to a flag state, because UNCLOS gives all the rights to the flag states, including providing the flag anyone. Flag of convenience countries actually provides flag to the countries, provide flag to the without any nationality requirement. So it's not always bad. It's a business decision. I'm not saying that flag of convenience is responsible for everything. It's even some very good shipping company may fly flag of convenience for some business advantage. I'm not going to discuss about that, but the responsibility. There is if we say that a vessel is used to attack against another country, a terrorist attack, and then flag state has no responsibility, that is not acceptable. So I explain what is my reasoning in that book. So at the same time, coastal states also, in my opinion, not everyone will agree with me, have some responsibility to ensure the security, because you see, the flag states have very limited ability to do anything within your territorial waters, within 12 nautical miles. The coastal state has the absolute coastal state has the jurisdiction, but at the same time, every country in the world has a right of innocent passage through your territorial waters. This is one of the conditions which is attached when countries agree that every country, coastal state can claim up to a 12 nautical mile of territorial sea. Because there was proposals of 3 nautical miles and all other different type of proposal. So if we see the historical basis, the Travex preparatories of the Law of the Sea Convention, we may say that yes, as a coastal state, I'm not saying that you have the coastal state has the responsibility to always guard the foreign vessel, give full security, but there should be a reasonable initiative from the coastal state to keep its water safe. That was my comment. Port state is within the port, most of the ports are within national water, clearly national water. So this is a different thing. It will be covered by the national law of the countries and other areas of international law. So what is the problem with cyber terrorism now? All my discussion in my previous book, as I said, that IMO SUA convention did not think about it. So my book was based on that convention. It's an explanation of that convention or other terrorism prevention convention. But cyber security, if someone doing something, sitting in somewhere else, in a different jurisdiction and hacking a system somewhere in Denmark, where the shipping company's office is based, or Hong Kong based. And then it's a bit more complicated than what was in the mind of the drafter of SUA convention and other post conventions. So we probably need, I've just started doing research on this, so I'm not going to propose what should be the amendment, but down the track actually, we probably need to amend. We can't amend UNCLOS. It's very difficult. It's a negotiation in the General Assembly. But SUA convention is the convention which is, the IMO instruments are, because IMO deals with shipping, which is a really truly international business. So the countries are more accommodating in the IMO to make any change than other forum. So SUA should be and it is related to maritime terrorism. So if we see any amendment in the future, that should be the SUA convention, not any other instrument. Terrorism-related international convention, I'll discuss about this. Since 1963, 19 international legal instruments have been adopted to prevent terrorist acts. Some are amendment of existing instruments, okay? So not all are purely new. And they are related to instruments regarding civil aviation, protection of international staff, taking of hostage, nuclear material, the maritime navigation, the one I'm talking about, SUA, explosive materials, terrorist bombings, the financing of terrorism, and nuclear terrorism. Okay, so there are 19, I'm not discussing about all of them, of course. How we have the SUA convention, which is the most important for us. History is after the Achille Lauro incident, which was an Italian flag vessel hijacked by some Middle East based terrorist group who actually killed a passenger on board. Initially it was not known. There was lots of negotiation. In one stage all of them were able to escape from the country, and then IMO started, and there was a consensus that we need to discuss this within IMO, International Maritime Organization. And then the majority opinion, as I said, that existing law was not adequate. So they wanted to have a legal instrument for maritime terrorism, which is similar to other terrorism convention. Then SUA was adopted, and after the 2001 attack in US, terrorist attack, further amendment of SUA was made in 2005. There was particularly to include provision regarding PCN weapon. PCN is biological, chemical, and nuclear weapon. And there was a fear in that time that terrorist organization may actually get hold of some of this. So supplying it, carrying it through ships was illegal for unauthorized, of course. There are nuclear power countries, they can of course carry it, but carrying it to give it someone like the terrorist organization is completely illegal, and any type of help to do that is also illegal. Okay, if you read, as we said, that SUA Convention, I'm not going to read this. SUA Convention, the crime, it's, what is it, like domestic criminal law, it's criminalized certain thing, and that's a very wider thing, and it doesn't say that how you do, how you endanger the navigation, how you kill people. If you kill people, it's a crime, okay? So, cyber crime can be covered within SUA Convention. So we don't need a new convention, a new legal instrument actually. You probably need a little bit of amendment of SUA Convention to make more specific because of this multi-jurisdictional and very different nature of cyber crime than other crime. So these are very wide. I'm just giving 1 minute time to read if you want to read some of the crime. Any person commits an offense if that person unlawfully and intentionally does this. So this is very important. Someone is awaiting, someone is helping using internet or communication system to do those crimes from somewhere else will be covered by this, awaits the commission of any of the offenses. Okay? If you see subparagraph 2. Okay. So for the maritime terrorism, we know that there are some jurisdiction of flag state for prosecuting the perpetrator. Coastal states may have jurisdiction if it is happened within its territory. States of alleged criminal can anytime can prosecute. It's not anytime if it is depending on its national law. I'm not an expert of that area. State of the victim sometimes claim jurisdiction. The state that is the object of compulsion. What is this state? A terrorist hijacked a French, German national to ask Norway to do something. That you release, they are asking Norway to release their leader from the Norway state prison. So that is the object of compulsion. Or a terrorist attack has hijacked some people from multiple national to ask their government to give them some political right within that government's territory. Okay, this is an insurgent group of a certain country who actually hijack some people and asking their own government to do this. So all those, then that government, that country is of object of compulsion, but at the same time it is the state of alleged criminal also. Someone else. And there are some interesting jurisdiction created by SUA Convention, like if a crime is committed in a vessel, the master can actually go to the nearest country and hand over the person to that country, and then that country can ask the flag state to take this person and prosecute. Or if the flag state doesn't prosecute, the country which received that criminal got no connection with the crime, because that was the nearest country and it is easy for the master to deliver them, they can prosecute. Or another very interesting provision in the SUA Convention is if a criminal found in any country, if an alleged criminal who did a SUA Convention crime anywhere in the world, within national jurisdiction or beyond national jurisdiction, which is high sea, if that person is found in a country, that country can should either should either prosecute or extradite to a country which is more interested to do it, like the flag state, or the country which is from the state of the alleged criminal, or they should prosecute. So if we compare the piracy provision of the law of the sea and SUA Convention's provision, in respect of creating the expense of the crime, the ambit of the crime, SUA is far better, it is wider, but piracy provision has an advantage. It created a universal jurisdiction. This is probably the oldest universal jurisdiction crime in the world. Not for just prosecuting, it's for even arresting. If a piracy incident is happened in the high sea, it must be always in the high sea. If it is in the coastal water, territorial water, it is not a piracy. Now we call it maritime armed robbery or something else, whatever. If piracy, if the government vessel, naval vessel of any country, know that something happening in the high sea, a piracy incident, they can go and arrest, take action. Not just arrest, whatever action it is needed. It can take and they bring them back, those pirates, for prosecution. But SUA Convention does not create this type of wider enforcement jurisdiction because of the jurisdictional complexity. There was a serious initiative from the United States after 2001 to broaden the scope of enforcement under SUA, enforcement jurisdiction under SUA Convention, but it was not successful fully. So a provision eventually included by 2005 amendment of SUA Convention for enforcement, particularly the boarding of the vessel, but that's a very weak provision. Okay, that's nothing compared to the wide power for piracy take action. Okay, I previously discussed about state responsibility for maritime terrorism generally for these four things in my book, and I still believe that they are fully valid for cybercrime, cyber maritime terrorism. And this was something new, to be honest, like flag state responsibility for aiding maritime terrorists. A state responsibility for aiding maritime terrorists or any terrorist is now very well established through Resolution 1373 of the UN Security Council. It is now, previously it was very complicated that you have to see, Nicaragua case and all this thing. I don't want to go through that general public international law matter. But yeah, after 1373, which is a Resolution 1373, there is a very clear ban from the Security Council for providing any type of direct or indirect help to the terrorist organization. And that is valid for any type of terrorism, including maritime terrorism. So aiding, and that's for cyber security. So again, at the same time, if you allow someone sitting in your country to hack somebody's computer some 10,000 miles away, if any state help to do that, they are violating 1373 of the UN, Resolution 1373 of the UN Security Council. All other, I have tried to discuss why one of my major arguments that all these countries have some rights under UNCLOS, and rights can't come with that. And at the same time, one of my major arguments for navigational rights was something, if I have a right of innocent passage, okay, through the territorial waters of other countries, which I have actually, if not, I mean a state, there should be a duty bearer of this right, for peaceful enjoyment of this right. And at the same time, that country also getting the right of having 12 nautical mile of territorial sea. This is part of the deal. We are talking about lots of deals now in the international politics, so that was actually part of the package. That, okay, we all will agree that 12 nautical mile will be territorial sea, at the same time other countries will have navigational right. So the responsibility for maritime terrorism will not be very different. Okay. When the amendment 2000 SUA protocol, this is about BC and weapon, there is one cyber-related provision, other than transport on board ship any equipment, materials, or software or related technology that significantly contribute to the design, manufacture, and delivery of a BCN weapon with the intention that it will be used for such purpose. Okay? There was one cyber-related provision, but this is all about actually transport of biological, chemical, and nuclear weapons. This one. But there is a very important development in the area of aviation. I said that there are 19 international conventions. 7 of them actually about aviation. Because aviation is a very, it's a very major concern. People's life is dependent on it. So there are lots of amendments. So there is a recent convention which was adopted in Beijing to amend 1972 to create a supplementary protocol to the 1970 Hague Convention for the Suppression of Unlawful Seizure of Aircraft. Any person commits an offense if that person unlawfully and intentionally seizes or exercises control of an aircraft in service by force or threat thereof, or by coercion, or by any other form of intimidation, or by any technological means. That was the important. So we probably need some amendment in the SUA Convention to make it wider so that any type of activities happening far can be through the internet or computer system can be included. As I said that I've just started research doing on this, so I will not propose any specific amendment, which I will eventually do, because I will form a team with some cyber security colleagues and cyber security law colleagues, because my area is mainly the maritime terrorism generally, and then we'll try to write something jointly where we may have more specific provision of what type of amendment we really want. So that's all from me, and I welcome questions.
Thank you, Dr. Karim. That was a very interesting talk indeed. When we start the Q&A section, I just one very quick and general question. So cyber terrorism, it seems it's pretty prevalent in many jurisdictions across the world. It's definitely a very serious threat in today's digital world, I think. So I was just wondering, what are the justifications to have laws just focusing on cyber terrorism in the maritime industry, as opposed to having general laws on cyber terrorism that are applicable to a wide different industries? And also a related question would be, since there would be general laws on targeting cyber terrorism, I'm sure there are other organizations or interested parties that are working on it. So is the IMO working in collaboration with those stakeholders? Thanks.
I think there is because IMO, second question first is that IMO is a specialized organ of agency of UN. So there is actually collaboration always. All of them are observed to each other, so other related organization will come. And thanks, David, for this question. And actually, it came. This was this discussed earlier also when we have SUA convention, or a specialized area-based convention like one for many, like 7 for not 7. Some are amendment, as I say, 7 for aviation, 2 for marine, 2 are amendments. Okay, see, the main reason actually we need separate convention in IMO, the way it's practically works, it's actually enforced along together with other IMO convention in marine areas. In the same, through same mechanism, port state enforcement and all these mechanisms is one. And then the ocean has a separate type of legal system than land. I can't say that I have right to drive a car via India to go Bangladesh from Pakistan. I can't say, because Indian government may allow That's not my right. It's a special arrangement by India. But in case of marine area, I can say that I can navigate a vessel through the Indian territorial waters to go Bangladesh from Sri Lanka or Pakistan, whatever country. And that's actually my right. Unless there is a very specified circumstance, India cannot deny. So because it works so differently, that's why all these marine legal instruments like almost 50 IMO convention, probably maybe 40 for different areas. So that was the decision in 1985 also to develop a separate convention for maritime terrorism. We have some general terrorism convention like terrorism financing, terrorist bombing, which I was mentioning before. And now actually, I'm not proposing a new instrument. It's maybe a small amendment after relevant research by IMO of SUA convention to make it more specific. I'm not saying that it is not covered by SUA convention. Many of the things that it just cyber means is mean. You are still doing. If someone even is stealing money from bank, it is still a theft or something like that. You are using now internet system to access it rather than going to the bank and taking it from there. So similarly, many of these existing SUA offense will cover the thing, but the specialized nature will probably, rather than, I think it will be better to have a small amendment in SUA convention. But at the same time, development generally for cyber crime, general international law for cyber crime is of course something needed, and unfortunately I'm not an expert of that, as I said, that general cyber crime or cyber related laws.
Okay, do we, anyone has any burning questions?
Yes, please.
Thank you so much for the talk. I want to focus on the word combating. You seem to be at a very strange point where I can hack you or conduct a cybercrime against you by a click of a button. And yet I'm looking at 5 or 6 screens full of very different, unreferenced or uncross-referenced legal documents that have tons and tons of language. And some of them are recognized by certain jurisdictions, and some of them, maybe to a lesser degree, by less sophisticated countries, are in principle recognized but not practiced. Law enforcement capabilities fluctuate tremendously, taking sophisticated economies such as the United States and then some other economies that just don't have the resources. How do we combat?
Law is a very small part of combating. But law may have a part, because there was some, the reason we are saying that the role of a legal framework for combating probably it is asking too much if we say that law will combat everything. But okay, I fully agree with you, the situation. Even some conventions which are not politically controversial, like MARPOL, is not implemented in many developing countries. And even SUA convention, Malaysia and Indonesia even are not party to SUA convention. So okay, this is the situation we are in. So I can't give you a very clear-cut answer that okay, we will combat in that way, law will solve. But we are trying to have a legal framework still when states are willing and able to work. But after the Achille Lauro incident, there are lots of willing and able states, but they were not able to do it because of the legal complication. That's why we needed SUA convention. So, but if we change SUA convention now again, it will significantly reduce the cybersecurity crime threat for cyber terrorism. We can't say that, but it will give a chance when a state is willing to do it. But if we don't amend it, don't do, at least we may not need the amendment. If we don't have a very comprehensive study, examination on it, we may have a situation where someone wants but still can't. And that was in Achille Lauro. And that is true for many terrorist incidents in the world now. Sometimes someone wants but can't because of some legal complexity. As I said, these are not cross-reference. And many occasions when we talk about UNCLOS, I don't think there was any discussion on terrorism when they drafted UNCLOS. The same thing I can say that there was no discussion on cyber terrorism when they drafted SUA. So this is someone can, if a lawyer comes with a very strong argument of a law like this in a national level, sometimes court will say, no, his interpretation is correct. Because there is, if you see the entire file of the Hansard or whatever of the parliament, that there is no mentioning of these. Now they want to interpret to criminalize this act by this law. So that's the fear I always have. That's why we need to have some. It's not a very significant amendment, but at the same, okay, it will be part of a very broader process of. I spent a large part of my life writing on implementation of IMO instruments. And that is my entry point of doing research in this area. So thank you so much for asking that question. This will be. We are not saying even if I am in law it will solve, but that's probably the first step.
Anyone else? Any other questions or anything for discussion? Yes.
If I understand your presentation correctly, you argue that the flag state should play a role in bearing some sort of responsibilities in this area. Can I use Hong Kong as an example? Because actually many ships are registered in Hong Kong. Hong Kong Shipping Registry is actually one of the most popular registries in the world. I don't know whether it's number 4 or number 5, ranking only after Panama or Marshall Islands. Is it your argument that there should be some pre-registration vetting to be conducted by the shipping registry, and also some post-registration obligation, which is continuing? It sounds very onerous on the part of the shipping registry. Yes, can you elaborate your argument?
Yes, many people will not like it. Yeah. I want them to take this onerous, otherwise they stop doing this because it's a playing with people's life. Okay, so flag state, because the entire IMO system and UNCLOS is based on flag state. It has the power. It can go anywhere to except other countries' territory and take action. It has the widest power. And every convention, everything you have actually will be implemented through flag state. Port state will have some power of detention, arresting, Article 218 of the UNCLOS and all these things. Flag state has a very serious power, and Hong Kong is a very good registry. But some other registry, they have offices all over the world. And they are run by private persons. They just give. Even there was people are advertising for end of life registration. Because the European Union has some restriction of sending their vessel to countries like Bangladesh for shipbreaking, openly, without any shame, registering to give end-of-life registration service. So the situation is that I am not against the flag of convenience or open registry system, but they have to take some, they must have in place some measures to at least. You can't always stop this thing to happen, but there must be, the flag state has some, in my opinion, as I said, that it was part of my PhD thesis, and one of very senior scholar actually did not agree, but still said that I should get the degree. Did not agree that this type of strong obligation exists, but he said that no, he doesn't agree, but he was my examiner actually. He said he doesn't agree, but it can stay in the thesis. So yeah, as I said that, yes, it's an argument I made that yes, flag state has, but I'm not saying that it's a small, they can prevent happening of this by doing this, but there should be an honest initiative from the flag state to see that at least who is they get their giving registration. Because nowadays a person can own. It's not a problem for majority vessel. Even the flag of convenience registration are coming from some very well-known, well-established shipping companies. So it will not be very difficult to isolate the problem. The cases where there should be a system which will be able to. But if it is coming from one of the biggest shipping company based in Hong Kong, or in that case it's not a flag of convenience at all. but coming from Denmark or somewhere where all those big shipping business are there. But if you see registration request is coming is from very unknown entity for the first time or second time. So there should be a database where you can check all the vessels are registered. You can't operate a vessel without registration or a flag. So there should be some checking, some initiative from the flag of convenience flag countries, flag states. Because if we say they are not responsible, then it is a lawless world. Because entire system is based on them. Yeah, I know postal estates have some, but it's mainly based on them. If we say they have no responsibility, then it's probably a very dangerous thing to do. That was my main argument, because in that case, we change the law, international law, and make it that, okay, you impose the nationality requirement, that you can only give the registration if the company is registered in your country. I'm not talking about all the shareholders, at least the company is registered in your country or something. Okay. I get your point that not everyone agrees with me, but somehow I was able to stick with mine.
Because I'm thinking of, like, I don't know, 500,000 vessels all over the world registered in Panama, and how is the...
No, because I have seen some other thing also, like shipbreaking. They are offering flag of convenience registration, and that is killing people in those industries. Unclean vessels are going. Some people openly offering in the website. End of life flag. The vessel entire life it has the flag of a European country. Now it will go to Bangladesh as a vessel of Vanuatu or Pakistan. So yeah, that's prompted me, because I have some information about, because as I said, I'm mainly an environmental lawyer. So what is happening in the shipbreaking industry? So that's why I have this strong opinion, I must admit, because I have seen some serious problem of lack of convenience apart from these security issues. So yeah, but I think Hong Kong is that was mainly targeting the flag of convenience. Hong Kong registry is very good, and it's not a flag of convenience. Most of they have some link with, because it's a major maritime center. So it's nothing to be surprised that Singapore and Hong Kong registry are big, but it is very surprising why Vanuatu registry is so big.
And I think that was a very good question. Just on the question of vetting, just follow up. In cyber terrorism, maritime cyber terrorism, do you think we can place some burden on the internet service provider rather than at the other end? So do you think that's viable?
Thank you so much for asking this question. One of my colleagues actually doing research on that, on respect of everything internet. He's one of the person actually asking to collaborate with me. He's like he's my number one target for this project to collaborate, and I actually know very little about that. But that's something we should and must examine. I'm not saying that we should do it, but yeah, someone doing this. Yeah, that's why this is a research project. After doing some study, I realized that I can't do alone. I need real cybersecurity law expert in this one.
Anyone else would like to raise something for discussion?